Then let's begin MA and J.H.M. If counsel, please step forward. May we please have appearances of counsel?
J.H.M. Counsel to confirm that we can file on behalf of the appellate defendant in this matter, J.H.M.
Morning, Your Honor. Michael Law, 146 Graham, Hawthorne. I represent the complaint.
Good morning, counsel, and welcome. We will go as far as we can until around 12:30. We may need to break for 30 minutes at that point and resume afterwards. Mr. DeMarco.
May it please the court, Chief Justice, Associate Justices, I would like to reserve 2 minutes of rebuttal with the court's permission.
That's fine.
The determination by the trial judge in an application for a final restraining order that the defendant's invocation of his privilege pursuant to the Fifth Amendment right against self-incrimination left the defendant with a Hobson's choice when the court denied it. That choice was a very difficult one for the defendant. Testify thereby waiving any potential Fifth Amendment privilege or declined to testify. And by doing so, the court could be permitted under our law to draw an adverse inference in the findings associated with whether or not the plaintiff had established the need for a restraining order by a preponderance of the evidence. The consequences of a restraining order, and in particular a final restraining order, are too great to allow not only the denial of the invocation of the Fifth Amendment privilege, but further to allow for this adverse inference to be used by the judge in determining whether or not the evidence presented during the hearing rose to that level of preponderance of the evidence. And therefore, this court should not allow this practice to continue here in our state. The consequences are just much too severe to allow this to go further. The issues framed for this court are two. One, did the trial court err in disallowing the defendant's assertion of a Fifth Amendment privilege against compelled self-incrimination when called to testify, compelled by the plaintiff's counsel in the hearing for the final restraining order? Two, did the trial court erroneously find that defendant would be subject to an adverse inference should he choose not to testify? When examining this particular issue, Judge, I'd like to start with looking at our Prevention of Domestic Violence Act. You know, it's often cited that it's civil in nature in terms of the application for a restraining order. Yet we find the statute in Title IIc, a criminal code. And we know that the issuance of a final restraining order depends upon whether or not a preponderance of the evidence is established that a predicate act of domestic violence, each of those predicate acts being crimes or disorderly persons offenses, petty disorderly persons offenses in our state, has been shown by the evidence.
Counsel, as you present your argument, please be sure to focus on where you think the appellate division went wrong. Please go ahead.
I will, Judge, Justice. I appreciate that. The trial court declined to allow the defendant to invoke his right to remain silent. She further indicated that based upon the law here in the state of New Jersey, that she would allow for an adverse inference. I believe that the trial court relied upon the reported decisions that deal with an adverse inference. I note for the record that there are two unreported appellate division decisions that go either way on this, whether a court should take an adverse inference or whether a court should not take an adverse inference. This court has previously declined to allow for an adverse inference to be drawn in the case of HES versus JES. In that decision in dicta, our court indicated that the exposure that the defendant faces in testifying and not being allowed to claim the privilege against self-incrimination could theoretically expose him to wiretap charges, which would be criminal in nature. Therefore, the unfavorable inference in that case should not be drawn against the defendant if he elects not to testify on remand. When the defendant appellate moved this court for permission to argue these issues, there were only two appellate division decisions that were out there, both unreported. Those decisions seem to differ in whether or not the adverse inference should be applied. Subsequent to our filing of this petition before the court, another panel did in fact issue a written opinion. And it is that particular opinion, TB versus IW, that stands for the proposition that this adverse inference allowed in our domestic violence cases, specifically the restraining order applications, should not be further availed here in our state. And the reason why is, a very fine review of the consequences associated with a final restraining order. We talk about the civil application of the matter, but the consequences are far more reaching than that. And part of what this appellate division opinion in TB had indicated was that it is not appropriate to draw an adverse inference solely from defendant's invocation of his Fifth Amendment right to testify in a final restraining order hearing. Why? The consequences are too severe. That panel went through some of the consequences that are associated with a final restraining order. The question is, are those consequences of such a severe magnitude that this adverse inference that is usually applied in a civil context be no longer allowed to apply in a final restraining order hearing? I note for the record that the decision in Merlino to apply the adverse inference dealt with the Casino Control Commission's banning of an individual from a casino because of his contacts with organized criminal activity. The application of an adverse inference in a civil matter involving a special civil matter or a financial matter is one of money consequence. Here in a domestic violence restraining order application, the enormity of the consequences were noted by Justice Albin in his dissent in DN versus KM. There, Justice Albin had indicated that not only can a defendant be expelled from the home, be ordered not to have any contact with children, suspend custodial rights, be ordered to pay compensatory and punitive damages, emergency monetary relief, seize firearms, suspend the right to own or possess or have a permit to carry a firearm, submit to a psychiatric evaluation, undergo professional counseling, being dispossessed of an automobile, family animal such as a dog, being fingerprinted, being placed on a central registry for domestic violence offenses, monitoring by the family court intake unit. And Justice Albin concluded that this is really akin to a stigma, a branding of that individual as a batterer. We know that the finding of a final restraining order can also impact employment. Certain professions, certain licenses have the ability to take or suspend an individual's ability to earn income or have a job based upon that finding of a final restraining order.
With you that an adverse inference is prohibited in a PDVA hearing, just like it's prohibited in a criminal trial because of all of these severe consequences that you just listed. could that also mean that a PDA defendant would then need to be constitutionally entitled to counsel?
Well, I think that was discussed also by Justice Alvin. And it's an interesting issue, Justice. It really is. When we look at the consequences of magnitude that this court has indicated require counsel to be either present, or if an individual cannot afford them, if they're indigent, to be appointed. We all know of our Madden obligations that attorneys take very seriously. A few weeks ago, I was in family court in Passaic County, fulfilling my Madden obligation. I looked out into the well of the court. There were 6 other lawyers that had been appointed to represent individuals who were alleged to have violated restraining orders. So that Madden obligation is clear when the domestic violence final restraining order is alleged to have been violated.
But that's because that's a criminal proceeding, correct?
Correct, Justice. But it also applies to municipal court proceedings, quasi-criminal proceedings. When we examine the need or requirement for counsel for a driving while intoxicated case, I note for the record that the consequences associated with DWI have changed drastically over the last 10 years or so. Certainly with the advancement of the interlock device and the ability of individuals to have that installed, so it would not interfere with their opportunity at employment. That's one of the compelling reasons why that law has changed so much. If we say that an individual facing the charges of a DWI municipal court is entitled to counsel, and if they can't afford it, they should have one appointed to, I believe the consequences, most respectfully, of the Prevention of Domestic Violence Act final restraining order are far more serious than the current penalties for DWI.
But it's
in the
not
state of
imposed
New
by the
Jersey.
state, right? The other party is not a state actor. It's not the state that's pursuing the action. So that's a distinguishing characteristic from a DUI, for example, or other matters, correct?
It is, Justice. I agree with you. And, in a municipal court, the defendant could not be compelled to testify in a DWI case by the state of New Jersey, by the municipal prosecutor, whoever standing in. Here in the state of New Jersey, we allow individuals, plaintiffs seeking restraining orders to compel the testimony of a defendant. Now, we protect it somewhat through the PDVA, but it's not a full protection. It's not the same as an absolute immunity.
Why isn't it enough? Why isn't 2C2529A enough?
I think for several reasons, Justice. The Dupree decision, allowing access to the hearings themselves in terms of cross-examination of either the plaintiff or the defendant, if there are any predicate acts that are either contemporaneously or subsequently prosecuted. It's also not enough because the courtrooms in our state, even though the applications for restraining orders are sealed, the courtrooms are open to the public. The prosecutor, the law enforcement could gain certain information that may not necessarily be available to them through their own investigatory techniques, just by sitting and listening to restraining order applications where the defendant is compelled to testify or face the consequences of the adverse inference.
Sorry, you mean that a prosecutor could just decide to walk into any courtroom on any given day, even though they're not there for work purposes, and then use that information going forward?
Absolutely, yes. There's
Why would the
nothing that
statute not preclude that?
the courtrooms are not sealed, Justice. They are open for applications for domestic violence restraining
Doesn't it
orders.
specifically say testimony given by the plaintiff or defendant in the domestic violence matter shall not be used in the simultaneous or subsequent criminal proceeding against the defendant?
It does. The testimony cannot be used. But the question becomes whether or not the prosecutor can gain any information from that testimony that leads them to a potential witness, that leads them to a timeline, that allows them to use that in a prosecution out of either predicate acts or other offenses. I think in this particular case also, it's important to note that, this is in the context of a rather tumultuous divorce that starts in early January of 2023, where the plaintiff is out of the marital home with the young child that the couple share together, that as the proceedings are delving into the divorce itself, there appears to be some communication between plaintiff's counsel for the divorce and defendant's counsel for the divorce, that defense counsel would accept service of process of the divorce complaint. For whatever reason, that did not occur here. And on April the 28th of 2023, Unexpectedly, an individual showed up onto the property of my client. And it is at that time that the allegations are that my client, the defendant, had allegedly pointed a firearm at the service of process individual, not knowing who he was. Criminal charges have arisen out of that particular alleged area of conduct. Those criminal charges are still pending today. One question that we have filed a self-defense in that claim, in that defense of that case. But one of the questions that we are faced with is whether or not that testimony adduced during the restraining order hearing could be the subject of a 404B application, because it does not squarely relate to a predicate act as alleged against the victim, but rather an act against the third party, that third party being the process server. So can something be gained from that testimony that would not necessarily be available to the state of New Jersey, absent our client making an affirmative decision to testify in his own behalf at defense of the indictable matter? I also note for the record that the predicate acts themselves, in so much as one of them is alleged to potentially be stalking, have not run by way of a statute of limitation. Domestic violence victims applying for restraining orders are told that they have a right to pursue criminal charges. They're given that information, importantly so. And I think one of the points that is somewhat lost in this appeal is that many of the practitioners in the area of restraining orders one day may represent a defendant who a final restraining order is being sought against. That practitioner that same day may represent a plaintiff in an application. So even though amicus here is not only the public defender's office, but also the Association of Criminal Defense Lawyers, the practitioners in this area don't exclusively defend individuals who have restraining orders sought against them. So the relief that we seek, that a defendant not be permitted to be forced to the stand, compelled to give up that Fifth Amendment privilege against self-incrimination, to allow the plaintiff to prove their case by a preponderance of the evidence, is not something that we look at as an advantage because we exclusively do work defending individuals who are having a restraining order sought against them.
Counselor,
Yes, Justice.
The implications that you describe seem somewhat speculative in nature, but we know that that's not sufficient, according to the court, right? According to the relevant precedent, splits as far as the implication. There's a reasonable fear that your client would have, whether that fear is not reasonable, whether it's hypothetical, whether it's speculative. Explain to us why it is, because what you've just provided is fairly speculative in nature. Explain to us why it is that your client has a reasonable, substantial, and real fear that those implications may come true.
I think when you look at the history of this particular case, Justice, those fears are real. Here in the midst of this divorce proceedings, the application for a temporary restraining order was granted in Essex County, transferred to Passaic County shortly thereafter. As the hearings were started, the allegation is that my client placed a phone call in violation of the restraining order. The plaintiff immediately sought a contempt proceeding. That application for contempt went and was reviewed by the state of New Jersey through the Passaic County Prosecutor's Office. They declined to prosecute. If this restraining order moves forward with the compelled testimony of my client, and there is a finding by the family court judge that a predicate act of domestic violence has occurred by a preponderance of the evidence, and under the silver standard, that there is that second prong, that there is a need for a restraining order, then that plaintiff has a finding of preponderance of the evidence. The standard to file a criminal charge is probable cause. Now, I'm not saying that a court reviewing that particular complaint filed by a citizen, the plaintiff in this particular matter, will look to the family court's finding of probable cause and say, okay, an issue has been resolved here. We are automatically going to issue this complaint based upon a lesser finding of probable cause for the issuance of that criminal charge. But certainly the allegations and incorporated within the application for the final restraining order would be the basis for a citizen complaint moving forward. It places my client squarely in jeopardy. This has already been attempted in July of 2023. It was rejected by the prosecutor's office and dismissed. I think in the application itself for the final restraining order, the plaintiff makes reference to that. The plaintiff makes reference to a higher burden of proof that the prosecutor utilized in making that decision whether or not a contempt charge should move forward. That burden of proof obviously being beyond a reasonable doubt.
Counsel, a number of the arguments that you've advanced appear in the recent decision TB versus IW. Are you essentially asking us to adopt the analysis there and the reasoning in that opinion?
We are, Judge.
Are the weapons offenses against your client still pending?
They are, Justice.
Is there anything you'd like to add to the reasoning and the arguments that you've already covered and what's in TB? Any additional points, please?
The only additional point, Justice, that we wanted to make clear in our application is that there certainly is a need for the prevention of domestic violence. It is a serious problem in the state, but the consequences associated with that finding are of such great magnitude that there should be a reconsideration of whether or not an adverse inference should be drawn and whether or not the defendant should have the right to invoke the privilege against self-incrimination.
TB framed the question as defendant's decision to invoke his Fifth Amendment right not to testify. And that's how you have invoked it as well. And here your client specifically invoked it when asked if he was married to the moving party, correct? But doesn't U.S. Supreme Court law hold that the Fifth Amendment allows defendants in non-criminal cases only to decline to answer particular questions and does not provide a blanket right to refuse to testify? And I'm referring to Minnesota versus Murphy, 1984.
I think it becomes a difficult process, Justice, if we start asking family court judges to rule on every single question posed to determine whether or not it directly incriminates a defendant in terms of a predicate act, whether or not it may be potentially in other crimes evidence that could be used in a third party prosecution of a matter. So we're asking this court to allow for non-use of that adverse inference, to allow for that, for lack of a better term, a blanket assertion, because to allow individuals to determine whether a question being posed to them could potentially be a waiver of that privilege against self-incrimination, I think is a very difficult task. And I think that is even more difficult for judges in the family court to determine on a question-by-question basis. In this particular matter, it was stipulated that the parties were married. That stipulation came from a co-counsel down below. So that was addressed. The other questions that were intended to be asked by counsel of my client, by plaintiff's counsel, directly related to events of July 4th and July 5th, either harassment or stalking or both.
But the PDVA, has been in place since 1991, correct?
It has.
And all the predicate acts, as you pointed out, are either crimes or DP offenses, correct?
That is absolutely correct.
So are you alleging that in every single case for the past 35 years, the defendant's Fifth Amendment rights have always been violated?
No, I'm not. It depends on whether or not that defendant has asserted that privilege against self-incrimination. Did that defendant take the stand and say, I refuse to answer any questions posed to me today on the grounds that it may incriminate myself? Did a court rule that that Fifth Amendment privilege was not applicable? And further, did the court say, by your silence, I will infer a finding, in essence, of domestic violence to a preponderance of the evidence level?
But it seems like that would happen in every case, because you point out that in every case, you have to prove predicate acts and that the predicate acts are always crimes or DP offenses. So wouldn't the defendant, similar to your client, have an incentive to invoke this, or have the same incentive as your client to invoke the Fifth Amendment in every case?
Where there is the risk that that defendant could face potential charges for the predicate acts, I think it's advisable.
But you pointed out that there always is that risk because the moving party themselves can file a criminal complaint, which only requires probable cause.
That is correct, Justice. And, I know for the record, when you look at the practicing manual authored under the guidance of the Supreme Court by the Attorney General, It speaks to the prosecution of final restraining orders without the defendant being present. If for whatever reason the defendant decides to not avail himself or herself to the process and decides not to come for the final restraining order, the judge in the family court is well within his or her parameters of making a finding that a preponderance of the evidence has been established, number one, of a predicate act, and number two, that there is a need for that final restraining order. The defendant does not have to participate in order for there to be a finding associated with the violation of the PDD Act.
And that brings me to the rationale for the adverse inference. Ordinarily, in a civil case, if a party refuses to testify, an adverse inference can be drawn because that party might have information that the other party needs in the case. Here, you just made the point that both prongs under Silver can be made even if the defendant doesn't show up.
Absolutely, Justice. That is the case in the state of New Jersey. I can say that as a practitioner in this area, for not as long as some of my colleagues, that many a time a defendant elects not to testify in the final restraining order application. Most often, there is no application to compel that defendant to testify by the plaintiff. And personally, I've never seen an adverse inference given in this area. Why? It's not needed. Plaintiffs can prove their cases. There is an absolute need for restraining orders. Having unfortunately and tragically not only investigated but prosecuted homicides as a result of domestic violence, there is a need overwhelming for this shield. But we also must be mindful that sometimes it can be used as a sword.
Differently from the way you're phrasing it, I would ask if, in your experience, do plaintiffs' counsel often call defendants as witnesses in their case in chief? Not because the way you're phrasing it is, are they compelled to testify? But I'm simply asking, is it common or routine that they're called as part of their case, saying they call witness number one, they testify themselves, and then they say, okay, now I'd like to call the defendant. Is that common?
I rarely see it, Justice. What I do see is the kind of flip coin of that in many of these cases, the plaintiff testifies and indicates what the predicate act was and what the need is. When they rest, the defendant then decides to testify and say, I didn't do the predicate act, and I'm not going to harm the plaintiff moving forward. So, the testimony comes out ultimately before the court. What we're saying in our application is by disallowing the Fifth Amendment privilege and going one step further, saying that we're going to apply an adverse inference, the consequences are too great here. And we do believe in what plaintiff's counsel indicated. We do believe that that's a bridge too far.
Yeah, very quickly, I'm sorry. The FRO hearing was stayed.
It was, Justice.
And that was because the judge recognized that maybe some of the questions would lead to criminal liability. Am I right?
That is correct. And furthermore, that the judge would also use the adverse inference. In this particular case, it's difficult that we ask for a stay of the proceedings in the family court. There is this divorce complaint also. It's been well over a year and a half that my client has not physically been in contact with his infant son. He's had limited visitation on Zoom with a child under the age of 3. We all know how much attention a child has maybe looking at a Zoom. So there is a substantial interference in this particular case, as is in many domestic violence applications or divorce proceedings regarding the visitation with my client's son, with children.
Can I just ask, I'm sorry, one more question?
Yes, Justice.
So you said that the reason that a defendant's rights have not been violated in every case since 1991 is, it seemed like you were saying an adverse inference is very rare. Is that what you were arguing?
Yes, Justice. I've never come across one myself in my practice. I've never seen the application made. I've seen situations where a plaintiff leaves the proofs before the court rests, and the defendant has, at that point, an ability to put on witnesses or give testimony. That happens very often.
Did you rarely see a plaintiff have seen plaintiffs calling defendant to the stand in their case in chief?
That is correct, Justice. Very, very
Which is
rare.
how this arose here.
That's correct.
And if you had circumstances where defendants don't testify at all, just leave it to the plaintiff's proofs.
Right.
Absolutely.
And sorry, here it was a specific request for an adverse inference from the petitioner, from the respondent.
Yes, because what counsel had requested of the court was not only to compel my client's testimony, to find that the Fifth Amendment would apply, and then go one step further to ask for that adverse inference.
Other questions, anyone? Anything you'd like to add, counsel?
No, Chief.
Thank you.
Thank you very much.
May it please the court. As the Office of the Public Defender routinely represents defendants in criminal domestic violence proceedings, I'm here due to our office's concern that the threat of an adverse inference in a restraining order proceeding will compel defendants to speak, particularly given that those defendants do not have a right to counsel in those proceedings, and that the compelled testimony will not be used against them in a criminal proceeding.
Try to keep your voice up a little bit, please.
Yes. So first, I'm going to address the adverse inference and then the immunity in the statute, unless this court has any questions about the attachment of the right. So I want to actually alert the court to an evidence rule, which was not discussed in the briefing or in any of the cases. I pointed it out to defense counsel yesterday, who in turn mentioned it to plaintiff's counsel. That rule indicates that the triers of fact may not draw an adverse inference from the invocation of a privilege. It's Rule 532. And it states, if a privilege is exercised not to testify or to prevent another from testifying, either in the action or with respect to particular matters, or to refuse to disclose or prevent another from disclosing any matter, the judge and counsel may not comment thereon. No presumption shall arise with respect to the exercise of the privilege, and the trier of fact may not draw any adverse inference therefrom. For some reason, none of the cases upholding adverse inferences discuss Rule 532, apart from State v. Johnson, which is a case from 1982, where the appellate division summarily held in a sentence that a probationer's silence could be used against him because the evidence rules only apply to criminal proceedings.
Could you give us a cite to that, please?
Yes, the case is State v. Johnson, 186 NJ Super 423. As Gann notes, the Johnson court's finding was clearly wrong because Evidence Rule 101 states that the privilege rules apply without relaxation, formal or informal. We should presume that the legislature was aware of this rule when it crafted the PDVA, and therefore they did not intend for a defendant to be compelled to speak by the threat of an adverse inference. This court should find that this rule prescribes the drawing of an adverse inference based on the invocation of the right against self-incrimination. In addition, I won't belabor this point because I think it's already been talked about at length, but the threat of an adverse inference constitutes unconstitutional compulsion because the penalties that result from the entry of the order are so severe. The losses are by default permanent and are backed by the threat of contempt. So although this is a private dispute between private parties, the consequences of the order are enforced by the state. And so that distinguishes this case from other cases between purely private parties. Another case in which the court adopted the same rule that it adopted in HES is SK. There, the court held that a family part judge may not draw an adverse inference of culpability against a defendant who invokes his right against self-incrimination to refuse to testify at a Title IX fact-finding hearing. We're asking the court to apply the same rule here and just to affirm that the rule that it set forth in HES. Merlino and Dorotron both.
So, sorry, in that case, it was in a Title IX case, there is a right to counsel because we have called it quasi-criminal, correct?
Because there are consequences of magnitude. That's correct.
So here, do you allege that the consequences that could follow from a PDVA FRO are consequences of magnitude such that acknowledging them would also include a right to counsel?
I believe that the consequences here are consequences of magnitude to that degree. I find it difficult to understand how, for instance, suspension of a driver's license, how that can trigger the right, but the consequences here, which can include loss of job, parental rights, loss of dispossession from home, immigration status, changes at all of that, doesn't also result in a right to counsel. So I think that this case is very similar to SK, and if anything, just speaks to the fact that there should be a right to counsel in these proceedings, and also that there should be no adverse inference drawn.
This is not meant in an argumentative fashion, but sometimes when a right is found, it falls upon the public defender to provide the representation. In responding to Justice Wainwrapter's question, were you giving the best answer that you thought applied, or were you speaking on behalf of the public defender?
I was giving the answer that I thought was best. As of now, given DN the appellate division decision was affirmed. In that decision, they said that there was no right to counsel. And this court didn't grant certification on the issue of whether or not there was a right to counsel. The appellate division decision in DNVKM held that there were not consequences of such magnitude in these cases. And I'm simply disagreeing with that.
I understand
Position.
your answer. You're speaking for yourself.
Yes. So in addition to that, the appellate division in Merlino and Duratron also indicated that the threat of an adverse inference could be coercive where the ultimate consequences of the civil proceeding are severe enough. So the consequences here, which are much more severe than just economic sanctions, are of that kind. Moving on to the immunity in the statute.
Can I just ask briefly, in your experience, have there been opportunities for the state to pull the transcripts from the restraining order hearings to be used in further prosecutions? Because your office wouldn't get involved in restraining order hearings necessarily, or even not necessarily the contempt proceedings even, right?
Right. We would not be involved in the restraining order proceedings, no, or in the contempt proceedings unless they are a fourth degree offense, which occurs when it's otherwise a criminal offense.
But what about other prosecutions that maybe have some tie in the restraining order hearings? Do you have any experience with that?
Yes.
Situation?
So since I'm not a trial attorney, I don't, but I've spoken with other attorneys at the office who advised me that in their experience, when they have a domestic violence case, what happens is the parties will request the transcript from the court, who will then give them a copy of it. They'll just file a letter and say, see Dupre, and basically they'll get the transcript automatically. I also can imagine or would assume that because the plaintiff has a right to file a complaint, they could just attach the transcript and then the prosecutor will have the transcript. I also want to point out that although the statute, it's 2C 2533, although it states that these records are confidential, when it says these records, what it's referring to are a list of enumerated records that are created to create this registry or this database. And that doesn't include all of the records. Like I said, it just includes the enumerated ones. It doesn't specify transcripts. And so I don't know that it's clear that a transcript in this case is really confidential under that rule. But even putting that aside, the statute also then makes an exception for when these records are going to be used in furtherance of an investigation or prosecution, which would also obviously apply here. So
Sorry, that's only for a contempt matter, right?
no, this is so the PDVA in its 2C 25, 33, and 34, it discusses the database that's created and the records that are going to be compiled and put in there. And in that, it states that these records are confidential. So that's not just with reference to the contempt matters, it's with any domestic violence order case.
But in 2529, it also says testimony given by the plaintiff or defendant in a domestic violence matter shall not be used in the simultaneous or subsequent criminal proceedings against the defendant, correct?
Yes, that's exactly. And that's what I'm planning to turn to now, which is the immunity in the statute and why it does not replace the right against self-incrimination. So the immunity in the statute, I'll read it, but it allows for the testimony to be used in many respects. It allows for the testimony to be used as impeachment, at least as the court in Dupre so held. It allows the testimony.
Was an appellate division decision, correct?
That's correct.
Has this court ever held that there's a right to use the testimony despite 25/29?
No, this court could overrule Dupre. And I will say that I think that the reasoning in Dupre is problematic. The court in that case held that based on the confrontation clause rights, that the defendant needed to be able to use the plaintiff's testimony in the DV case as impeachment, because otherwise that posed constitutional problems, and then went on to conclude that the same must be true for a defendant's testimony, without really explaining why that's the case. So I acknowledge this court has never held that, and I do think that there is potentially a reason to hold that that is not what the statute says. But putting aside Dupre, there's other portions of the statute which allow for the testimony to be used. First of all, it doesn't prescribe the derivative use of the testimony. So the testimony can still be used indirectly to obtain other evidence, which could then be used in a criminal case. It doesn't prescribe the use of the testimony to prove other acts which don't arise from the same incident as alleged in the domestic violence complaint. So for both of those reasons, in addition to Dupre, just leaving it as it is for now, or assuming that it still stands, there are three different cabins or ways that the testimony can still be used against a defendant in a criminal proceeding. And this is a problem because the right against self-incrimination doesn't allow the testimony, or doesn't allow compelled testimony to be used in any of these ways. And so I cited in my brief a number of cases to this point, and I'm happy to cite them here, but Castigar, Patton, Strong, Portosh, these are all cases saying that the testimony, compelled testimony, cannot be used against a defendant in any respect.
Can you go back to explain the derivative use point? I understood, I think, but can you explain the other point? Because the language seems pretty broad, where it says testimony given by the plaintiff or defendant in a domestic violence manner shall not be used in the simultaneous or subsequent criminal proceedings against the defendant. It doesn't say as to that particular act that was testified to, or as to only the crime in question that was being discussed. It seems very broad.
Right. Yes, that's true. But the clause prior to that says if a criminal complaint arising out of the same incident, which is the subject matter of complaint brought under the statute, has been filed, comma, and then the portion to which you are referring.
So you mean if a criminal complaint is filed on a totally different?
Yes. Or for instance, in this case, the court process server case, the plaintiff actually concedes in this case that the immunity would not apply to that case, which means that testimony in this case, which came out, could then be used against the defendant in that process worker case.
What was the charge on that?
And my understanding is that's unlawful possession for an unlawful purpose. I could also imagine in an assault charge based on just what I know about the facts of the case.
So if he testified at the FRO hearing, that testimony could be used in the process server case.
Yes.
And with the state of the law as it is now, the prosecution possibly could use the testimony to impeach defendant's testimony during that process server criminal case. And of course, the defendant's decision to testify at all would be impacted by the potential impeachment to come.
Yes. So yes, exactly.
But it can be used affirmatively.
It could be used affirmatively. It could be used as impeachment. It could be used indirectly. So those are the three buckets which the right against self-incrimination doesn't allow: impeachment, indirectly, and to prove a different offense that is not the same incident alleged in the domestic violence complaint. So there are for three different reasons, the immunity included in the statute is not coextensive with the right against self-incrimination. And I want to talk a little bit about the legislature's intent here. I think that if this court finds that an adverse inference is inappropriate and precluded, the immunity in the statute still serves a purpose. It still encourages a defendant to testify voluntarily. And some defendants will want to testify voluntarily because they want to, say their piece. They want to tell the court what they think happened. And so by holding that an adverse inference is precluded, that's not going to negate the intent of the legislature. And what I don't think that the legislature intended for a defendant to feel or to be compelled to speak. And I think looking at the evidence rule, which states that an adverse inference is precluded in these circumstances, and by looking at the immunity in the statute, which is very limited, you can tell that that was the legislature's intent. The legislature knows how to craft an immunity statute that provides for fulsome immunity. It's done so in other circumstances. And if it wanted to, it could provide for that immunity, and it could say that a defendant does have to testify in a domestic violence proceeding. Unless this court has any other questions, I think I'll just conclude by pointing out one small thing, which is that the standard for demonstrating what is incriminating is a very low bar. And the court should affirm the defendant's invocation unless it's clear that the individual is clearly mistaken, that the testimony cannot have such a tendency to incriminate. That's from Hoffman 341 US 479.
And you're referring there to the Fifth Amendment invocation.
Yes, yes. And
standard for invoking.
yes, yes. There were some questions earlier about whether or not the fact that the right attached is speculative. And so I'm just responding to that by saying that the bar is really low here. And Hoffman is a US Supreme Court case, but 502, the evidence rule, adopts that same language and makes clear that the bar is really low here. And given the nature of this proceeding, the questions right here are all going to be possibly incriminating. That standard is going to be met. And so for these reasons,
because the Fifth Amendment, is of course national and a bar in every state, is there any other state that has a rule that no adverse inference is permitted if a spouse refuses to testify at, or a party refuses to testify at a civil domestic violence restraining order proceeding?
I wasn't able to find any other cases addressing that or saying so. But I will say,
so such a Fifth Amendment rule has never been declared by any other court.
No other court, as far as I have found, has said that an adverse inference in this context constitutes compelled speech.
Or is required under the Fifth Amendment.
Or is required under the Fifth Amendment. No, well, the adverse inference would never be, there's nothing mandating the adverse inference.
So I'm sorry. My question was, has any other court held that an adverse inference is precluded under the Fifth Amendment?
No, there's no other court that has held that.
But have you found other cases addressing this specific issue around the country?
Not specifically with reference to domestic violence, but with reference to other criminal or civil consequences. So
generally, adverse inferences are allowed pursuant to U.S. Supreme Court law under the Fifth Amendment, which is the only thing that they're interpreting. They say regularly that an adverse inference is permitted in a civil case, which technically this is.
Yes. And so that is the reason that I think that, going back to Rule 532, I think that the reason that the New Jersey cases have not cited Rule 532, which says that an adverse inference is improper, when someone invokes their right, you can't draw an adverse inference from that invocation. The reason that I think that's happened is because I think that we've been looking at the federal case law, which indicates that this is proper and permissible, but there is no federal analog for this evidence rule. So no, I have not found any cases saying that an adverse inference in a situation like this is impermissible.
But that's helpful that you said there's no federal analog to this rule.
To the evidence rule, yes, exactly. And there is case law in New Jersey to support a rule that an adverse inference in this situation does result in compelled speech. And that goes all the way back to Duratron and Merlino. Those cases specifically condition their holding on the fact that the final consequences that were to result from the proceeding were minor. They were money damages and they were exclusion from casinos. And so they specifically carved out the possibility that there would be a case where the consequences would be so severe such that the threat of an adverse inference would result in unconstitutional compulsion. And the court in SK obviously adopted that same reasoning that we're asking this court to adopt here. And this court in HES said that it understood and agreed with this reasoning. Although it's in dicta, we are just asking the court to affirm that rule here.
And again, the whole point of an adverse inference is to level the playing field. If a party has information that the other party doesn't have and refuses to testify, then the court can draw an adverse inference. But here, that rationale does not exist.
Exactly. That's exactly right. And as you are all aware, every day in criminal cases, that the state is able to prove beyond a reasonable doubt that our clients commit these same criminal offenses. And there's no reason that a plaintiff in this case cannot prove the same by a preponderance of the evidence. So unless this court has any further questions, we ask the court to hold that the threat of an adverse inference constitutes unconstitutional compulsion.
Thank you, counsel.
Chief Justice, Associate Justices, may it please the court, I will speak louder. I have to make a few changes here. Good afternoon. I originally had written good morning. I am that older attorney that my esteemed counsel, co-counsel, adversary indicated. I've been practicing 39 and a half years. This is my first time here, but the issue that's before the court arises, of course, out of a domestic violence matter. I've tried about 100, probably more than 100 in my career. And I will tell you, because many of the questions that were asked do beg for answers. Some of those were posed. Most of these cases are tried by pro se plaintiffs and defendants. Most of the parties are unrepresented. There are represented parties all the time, and it is not infrequent that counsel for the plaintiff calls the defendant to the witness stand. It does happen. And it happens in instances like that present here in this case, where there's information a defendant possesses that is not known to the plaintiff. It happens frequently. I've had this in matters where my client received 250 text messages from her former boyfriend. She received them between 7 in the evening and 3 in the morning. Not in this case, in a different case. And she had the record of her phone record. Her record showed I received from this number, but she didn't have the corresponding proofs he sent them from his phone. So in that case, it is of necessity that the defendant is called to the stand to say, are these the records from your phone? Because I've also had cases where there's a spoof, where the defendant didn't send the messages, yet they appear as his phone number on someone else's phone. So there are any number of circumstances where a plaintiff needs the defendant as a witness in a case. The Act for the Prevention of Domestic Violence is civil. All the talk about quasi-criminal, there's no such thing in the law. We have civil cases in the Superior Court. We have criminal cases. This is a civil case. Civil rules have to appertain. The civil rules include the right of an adverse party to call the other side to the witness stand. That happens in every form of civil case and shouldn't stop here. In that case, the defendant is required to answer questions. Every question asked needs to be answered unless there's a properly laid objection to that question. When a Fifth Amendment privilege is invoked in a civil case, and it does and can happen, the court has, in all civil cases, the right to draw an adverse inference. That's constitutional law as interpreted by our Supreme Court. In the cases were cited earlier, it is also as stated by our courts in this state. But there is absolutely, and in fact, our courts have gone so far as to say, it's ingrained in our jurisprudence that this can happen. Trials happen question by question. They don't happen otherwise. And trial judges are called upon every day of the week to make calls on each and every question posed. Objection, sustained. Objection, overruled. Objection, is there a hearsay objection, something that overcomes the objection in terms of hearsay, in terms of anything else? So to give a blanket rule, a blanket immunization to defendants, you no longer have to answer questions in a civil case, undoes all of our civil law. All of our civil law does in fact allow this to happen. And there's nothing so special about restraining order cases that say we should create a brand new way of trying cases. And that is, if the defendant is called to the stand, he could say, no, thank you. Or she can say, I don't choose to get there. I choose to remain silent. The court in TBVIW had a very different fact scenario, and I think some members of this court asked the questions. In TBVIW, the defendant sat there with his hands folded on the table. His attorney stood up and said, the Fifth Amendment is, he kind of said, it's my favorite amendment. I mean, if you read what was said in the opinion, he said, it's a bedrock amendment. It's something that is vital, and therefore, I'm not going to put my client on the stand. And the court below took an adverse inference and said, I now find that everything she said is true because he didn't speak. TBVIW is bad facts, and bad facts do lead to bad law. And the bad law here is the blanket proposition. And that's what has to be avoided, because there are circumstances exactly like that present in my case, in this case, which allow me to get to the truth. And isn't every civil case about getting to the truth? Chief Justice wrote an opinion indicating we narrowly construe privilege. Privileges fly against the truth. Privileges stand in the way of the finder of fact gathering all of the information necessary to make a ruling. So whenever we look at a privilege, we construe it narrowly, and we do it, as was in Franklin, case by case, question by question. That's the painstaking way we try all cases. There is nothing different about these type cases that requires a different rule. Again, they're not quasi-criminal. Again, in the circumstance that's present here, and I do believe that there were some questions by Justice Facial about, well, what need would there be for a plaintiff to call the defendant to the stand? There are reasons why that may happen. And when a question is posed, and that question is, again, using the facts of my case, did you drive by her house? If he invokes a Fifth Amendment privilege to that question, I say, Judge, I ask you to draw an adverse inference. In the case below, Judge Adrians and the presiding family judge in Passaic County said, I would be inclined to draw the adverse inference.
Even if the, I'm sorry.
Yeah.
Even if the answer creates criminal liability.
Yes, because there's an immunization for that particular question under the statute.
What about, I'm sorry. An answer to that question about did you drive by the house could create a criminal liability for a contempt case, violating a restraining order.
Because again, you're talking about a future indefinite. You're talking about that not only is here going to be a finding that there's going to be a final restraining order, but then you're going to find there'll be a violation. And when that violation occurs, then you're going to be able to use that testimony. It's, again, speculative and indefinite. And I don't believe that, you know, the question has to pose under Hoffman, present danger. Doesn't say, you know, future danger if 15 other things happen.
So in this case, looking at Section 29 and the language of Section 29, defendant currently has a pending criminal case, correct?
That's correct.
And that pending criminal case does not arise out of the same incident, which is the subject matter of the complaint in the PDVA proceedings, correct?
That's correct.
So does this immunity in Section 29 apply to the use of defendant's testimony if he were to be compelled to if he were to testify at the PDVA hearing in his current criminal proceeding? No speculation. We actually have a current criminal proceeding that is taking place right now. Would this testimony be able to be used against him?
I was sitting here so anxious to answer. I wanted to jump in. I apologize. The answer is no.
Anxious to hear it.
No, he's
Okay.
not protected.
Okay,
He is
why?
not. So here's what happens. And trial judge, Judge Adrianson, actually ruled on an evidence issue earlier in the case. There's a video of the defendant standing there pointing the gun at the process server. I asked that that video be admitted into evidence. Judge Adrianson said the prejudicial value of that video outweighs its probative value. I will not allow it. And her reasoning was essentially along the lines, and I really can't disagree. I don't need to know that he pointed a gun at somebody else. I can allow your client to testify that that incident made her fearful. But why do I need to see the video? Now I'm going to think he's just a bad guy, and I'm not allowed to do that. So that's why that evidence is excluded. If the witness says, if I say, did you point a gun at a process server? The witness will say, I invoke the Fifth Amendment. No adverse inference can be drawn because he's now in jeopardy. And the
But who makes
difference
that
is there's
determination?
jeopardy.
But who makes that determination and how?
The trial judge,
So your argument
Based
is
on-
it should be question by question.
question by question, has to be. That's the way we've always done it. That's the way every civil case proceeds, question by question. If you've ever sat in the lower courts, this is how we try cases.
But what
No,
do you
you
do in the
painstakingly.
what do you do in the circumstance where it's two pro se parties? The judge now has to make a finding on that question's admissibility based on the invocation of the Fifth Amendment rights, based on information that is outside of the court's possession regarding a prosecution that is not a part of this case. Nobody's aware of it. And the defendant is saying, well, I'm subject to prosecution on this case. And the judge is going to make a call in the abstract on those facts.
Judge is going to have to make those calls. What will happen is, again, you have two pro se witnesses. If the defendant has the wherewithal or foresight to say, I'm not going to answer that, I invoke my Fifth Amendment right, I'd be hard pressed to imagine that the plaintiff will say, well, I ask you for an adverse inference. And the judge, sua sponte, is not going to draw that inference. But if the request is made, the judge can make the call like in every other case.
Why wouldn't the judge make it sua sponte if we direct the court that they can? Why wouldn't the judge do it sua sponte?
It can be ordinarily a request for an adverse finding is made to the court rather than the court sua sponte doing so. But I suppose it could be the case that the court would say, sir, you're in grave danger if you answer that question. I'm going to suggest you don't. If you choose to do so, fine. And if you do, I'm not going to draw an adverse inference. You may have that interplay with the court. I don't know that you will.
Sorry, go ahead.
Okay.
Doesn't that put a unrepresented defendant in a restraining order context in a very difficult position to have to decide whether to testify and risk possible prosecution in a future case versus they're trying to save themselves from the restraining order in that case when the judge is the one telling them you can either testify or invoke your privilege, but I may hold this against you if you don't testify. Isn't that the compulsion that we need to be worried about?
No, Your Honor, because in fairness, this is the circumstance where the testimony is to an unrelated charge, such as pointing the gun at the third party. In the context of the charges at hand, in other words, if the charge is assault, and the question is, did you punch me in the face? And this is asked, and the answer is, I take the fifth. The judge can say, I draw an adverse inference because I'm going to now assume you would answer the question, yes. And that the difference is whether or not the question goes to the current action, which is the first part of 29, 2C29. It does say related to the current action before it goes into the second part. Questions unrelated to that action are frankly subject to a Fifth Amendment invocation.
And are you saying there could be no adverse inference just because it has no relevance to the case? Because it's about a different charge that's not part of the proceeding?
No, I'm saying there'd be no adverse inference because there's jeopardy. Because if I ask you the question, did you point the gun at the process server? And you answer yes, that can be used
And
under
that's
the
because
statute.
2529 wouldn't apply in that
That's
circumstance.
correct. It does not. It does not.
You referred to Section 29 earlier as an immunity statute, but it really doesn't provide immunity in the traditional sense.
It doesn't.
It offers specific limited protections, right?
That's correct.
So in the hypo that we've been talking about, if the question where did you put the gun at the process server, and the next question was anybody else there to see it? One could make derivative use of that second answer and go and follow up and interview person XYZ who may have also been present, right?
Well, except that the initial question, if there's capable counsel on the other side, is going to say, I direct my client not to answer that question. And then there are no follow-up questions. I cannot get into the follow-up questions. Like Judge H.M. specifically ruled, stay away from. She admonished me, you're going to stay away from the gun issue. And I said, I will.
I was using the gun issue not for the specifics of this case, but to ask the question about derivative use. And there is no immunity in the traditional sense for derivative use of information that comes from the putative defendant's mouth.
That's true. And that's the same in every other case. The issue here is, can I put the witness on the stand? Let's not lose sight of what we're really talking about here. I called the plaintiff, the defendant, to the witness stand. I want to ask him questions about this case. Did you drive by her house? Did you place a phone call to the CCU at the hospital in the middle of the busy time of day? Did you do so by giving, and I hate to tip my trial strategy, but I'm going to say this. Did you give your given name when you did so? Or did you use an alias? And those are parts of the elements of what I'm trying to prove in my case in chief.
But even in that example, they're potentially subject to prosecution separate and apart from the underlying facts of this case.
No, not under.
Somebody giving a false name?
That's all part of the anonymous phone call. So it's all part of, it's a
Saying that
form.
would be immune under 25, not immune, but that could not be part of a criminal prosecution under 25.
Correct, because the false name was given with the purpose, if you follow it through, to cause alarm, annoyance, harassment of the recipient of that call. There's no independent, giving a false name to an authority might be a different issue, but giving a false name to one's spouse or that a receptionist to answer the phone, not a crime. It's a crank call.
Counsel, you specifically elicited testimony about gun use. I'm looking at transcript, page 70, line 25. I told him guns are dangerous around my son. And you said before, well, it's either related to the incident or it's not related to the incident, but there's a massive gray area in between. 404B fills a lot of that gray area up. So you've elicited testimony about gun use in the FRO proceeding that could certainly be relevant, at least on a 404B basis on the prosecution. Isn't that exactly what should be avoided?
No, because the questions were being asked of the plaintiff. She's my witness. I put her on the witness stand and I asked her, and the questions are relevant only insofar as they go to her state of mind. When you try a domestic violence case, you can't understand what happened unless you understand the dynamic of the relationship. You have to learn the family before you can understand what happened. So if I said to you, I'm going to bury you, and I'm some nerdy lightweight, nobody's going to care. If I'm Tony Soprano, you will be afraid. And if there's a history of violence, if there's a history in this case that this man pointed a gun at a process server, if you follow this through, I'm not asking that for proof of whether or not he did so. I'm asking that as to the state of mind of the plaintiff. Bless you. Did you have good reason to be fearful of this man? And she says, yeah, he's unhinged. He pointed a gun at a process server.
And it may come in the prosecution in a very similar way.
But the prosecutor can call her as a witness. The prosecutor can't call her, but it's not relevant to the prosecution on the gun charge because it's her state of mind. She didn't see him point the gun at the process server. She learned of it, but she was not a witness who understood what was happening there. The only thing she saw was on a Ring doorbell camera, and that video evidence is already available to the prosecutor.
But that's really an issue of hearsay, isn't it?
Could be, but it's again not relevant to the issue to respect at hand. The issue at hand is we're getting back to the idea of this blanket prohibition blanket prohibition that doesn't exist elsewhere in the law that will give a complete immunity to a defendant. Not the immunity under the statute now, but complete immunity from answering any questions, anything. Are you married? Take the fifth. I mean, it would go that far that he never takes the stand, even if I call him as a witness. Not how we try civil cases is my point. And it really does change the law. And you don't even have to overrule TBVIW to get there, because the facts of that case are exceedingly different from here, because in that case, the defendant chose not to take the stand and the plaintiff didn't call him. I called him. I called the witness.
Now, you agree, though, that despite the fact that this case comes up within the family division, and you yourself said it was a civil case, and that's what you've always noted to be, that your adversary's argument about the consequences make it completely distinct from any other type of civil action that we have in our jurisprudence.
It is, and I would say that if we're going to look at the consequences, then we have to look at them for what they are and why they are. And we have to look at the context, because whenever we've looked at cases like Doratron, where what was at stake was a money judgment, or Merlino, where he got kicked out of a casino because he hung out with Scarfo, I believe is who he was associated with. He was kicked out of a casino. Those are fairly light. On the other side of the coin is the state of California holding over the head of an attorney this barman if he doesn't flip on his own client. And in that case, the power of the state was at play. So I think that's the first critical difference here.
What is that case, counsel? The California case?
I wrote it down. Give me one moment.
If it's in your brief, it's.
Yeah, it was. It's cited in Doratron. I wish I could read my own writing. I know that it's Malloy and Murphy are two of the cases. Garrity speaks to this also. It's the compunction of testimony by the state, which is different from compunction of testimony, if you will, by a plaintiff who stands in the balance as an equal.
In your experience in the many trials you've conducted in these proceedings, how often is the other side represented?
If I'm in the case, more than 50% of the time, the other side gets an attorney as well.
And how often does one side call the adverse witness to the stand?
10%. It's not a huge number. It might be 10% of the time, might be less. Anecdotally, Your Honor, I don't have any real statistics here, but I would say in my lifetime, I have done it multiple times, but it's infrequent. 5%, 10%. But there are cases where you have to.
Has it been your experience? Have you had the experience when similar to this case that an adverse inference was drawn? Excuse me.
I never got to the point, to be honest with you, of somebody invoking the Fifth Amendment privilege. In most cases, if I've called the defendant, the questions are answered, because I think all of us who do this kind of work recognize that there is some form of, and I understand, Your Honor, it's not immunity in the traditional sense, but there's some form of an immunity that you can testify about the events that happened between the two parties and not face prosecution on that series of facts. So more often than not, the question is simply answered. And the Fifth Amendment, in my experience, has never been raised.
What is your position on Rule 532 that the public defender raised?
It doesn't apply. The title, if you look over the top of the rule, speaks to, and I actually wrote this down, reference, right? The title says reference to the invocation of privilege. And it says very specifically, if privilege is invoked by a defendant, then you can't tell the jury, see, he didn't speak, he must be guilty. That's what that evidence rule actually precludes. If you look at all the cases reported under there, every one of them is a criminal case. Not any of them apply in a civil context. So it is a rule, and quite honestly, it's kind of, and I don't mean to be disrespectful, but hard to imagine that all these years we've been doing this, nobody thought to look at the evidence rule before. I submit that that evidence rule only applies to criminal cases, and it speaks specifically to not speaking to, not addressing or referring to the silence. You can't draw an adverse inference if there's a properly invoked Fifth Amendment privilege. My submission to you is, in this case, the invocation of the Fifth Amendment is not properly invoked because there's no jeopardy. You can't face jeopardy if the statute gives you some form of immunity
For certain questions.
for certain questions. Absolutely. And that's why I think the blanket rule, which is not something that has ever been endorsed by this court or any court in this state, blanket rules like that do not tend to exist because we need to allow triers of facts to get to the truth. And if you put this kind of blanket rule in, think of what you're doing to the plaintiffs in this case, because that's the statute literally says in its preamble, to the greatest extent possible, we need to protect the plaintiffs. In this court's 2022 manual, you know, the 144-page domestic violence manual, it indicates that there's approximately 10 million victims of domestic violence in this country each year. 1 in 4 women, 1 in 9 men will experience severe violence at the hands of a significant other. Those numbers are mind-blowing.
That's why the burden is different in the domestic violence context than it is in the criminal context. And just like in the criminal context, defendants are privileged to remain silent and not have to speak and are still able to be prosecuted and convicted. And doesn't the same hold true in the domestic violence context on a daily basis, where just the plaintiff testifies and the court imposes a restraining order despite not having the defendant's testimony?
The defendant's non-appearance can result in the issuance of a restraining order. There's no question. However, the defendant's non-appearance doesn't relieve the plaintiff of having to put on the record the requisite proofs under Silver. Under Silver, you got to have a predicate act, and you have to have a concomitant need to protect. So the testimony still has to be elicited. The judges will not do a default and simply say, yep, you win by default, he didn't show up. You have to put on the record your proofs.
So if the defendant did not show up for the hearing,
Correct.
you would still put in the proofs to meet both prongs.
That's correct.
And you would be able to establish the predicate acts of harassment and stalking without him.
That's correct. In many cases. There might be a case, though, Justice, where I really can't prove the predicate act without the defendant. It is entirely possible that that set of circumstances exist. And in that case, I'm going to issue a subpoena. I'm going to subpoena the defendant and compel his testimony. In many cases, there's no formal discovery in these cases. The law says try him within 10 days. It's kind of crazy, but it does say that. There's no exchange of witness lists. And I did catch my adversary in this case a little bit flat-footed by not telling him, I'm going to call your client. I did not. I told him I was going to call her brother. True statement, I was going to. But the fact is, when I called him to the witness stand, he really wasn't prepared. But in other cases, I might issue a notice in lieu of subpoena. And I might say, I expect your client to not only be there, but to testify.
So you're advocating for a question-by-question scenario. And under certain questions, you're contending that a defendant can properly invoke the Fifth Amendment protections, correct?
That's correct.
And in those circumstances, it would be improper for the judge to draw an adverse inference, right?
That's correct.
Okay.
Because that is really what Hoffman says. You can't, and again, if you look at Franklin, it speaks to the fact that we tried these painstakingly, question by question. When you read a transcript, you see it's voluminous. The transcript in these cases, these take hours. I have tried domestic violence cases that have taken 2 weeks. Kind of crazy, but I have. And I'm sure Mr. DeMarco has as well, because sometimes you have multiple witnesses. Sometimes you have substantial questions of fact, or in this case, of law. And one of the things that was asked here is, how did we get here? Judge Adrianson granted the right to appeal to the appellate division on this issue. So she said, I'm going to stay the proceedings to allow you to go to the appellate division. The appellate division said, we don't want to hear it. And then came TWVIB and all of us are TBVIW, which now says, time out, everybody. We've been doing this wrong all along. And I think that's really to your point earlier, Justice, when you're talking about, are you telling me we've been doing these cases wrong all these years? You could read TBVIW to say, yes, you have. You should never, ever draw an adverse inference. I'm saying that that case can be and should be limited to the circumstance, if the court doesn't want to overrule it, where the defendant willingly sits there with his hands folded and said, I'm not taking the witness stand. That shouldn't relieve the plaintiff of his or her obligation to still prove a case.
What would the rule be? How would you craft the rule for those circumstances where a defendant properly invokes the protections under the Fifth Amendment and therefore would not be subject to an adverse inference? How would you craft that rule? What would you say?
Well, I think it exists as it is today. It's how we've always tried these cases. So again, in this case, hypothetically, I say, did you point the gun at the process server? I invoke my Fifth Amendment right not to testify. I say, Judge, I'd like you to draw an adverse inference. And she would say, absolutely not. He's in jeopardy. I will not draw the adverse inference in that case, because adverse inferences can only be drawn in the circumstance where there's no direct jeopardy being, or the implication is so slight, like you're going to get kicked out of a casino. In this case, he faces you asked this question, second and third degree charges. Serious charges. Second degree carries a presumption of incarceration. I don't do a lot of criminal law, but I do know that. So there's the presumption of incarceration. At that point, if I ask him that question, he literally would be admitting, yes, I did put the shackles on me.
What about a case where there are no charges pending, but the statute of limitations has not run on potential charges? Would you then make the argument, this is speculation, Judge, he shouldn't be able to invoke the Fifth Amendment, right?
Sorry. No, the answer is, in that case, you could properly invoke, because there's danger in the question. The danger in the question doesn't require existing charges. It requires the realistic potential that if I answer that question, I've put a noose around my neck.
So that would be the question. With every question, is there a realistic possibility?
No.
That's the question, but that would be the question by question determination that a judge would have to make, correct?
That's correct. Each question as it arises is going to have to be evaluated by the judge if there's an objection. And don't forget, some of these questions.
You're saying that's how it works in every civil case, and that there is no context in which a defendant has a right to not testify at all in a civil case.
That's true. That is the statute. The statute says that in a civil case, two statutes. One, an adverse party has an absolute right to call the other side to the stand. And two, there's a statute, and again, I don't have the citations right in front of me. They're in my most recent submission to the court, that the defendant has an absolute obligation to answer the questions posed. And the only time that won't happen is there's an objection to a question. Many of the questions you're referring to might be irrelevant, in which case the judge is going to say, Mr. Pasquale, that's not a relevant question. It doesn't go to anything in this case. So I'm going to disallow it.
So I'm just not sure it's as simple as you propose with regard to this question by question determination. And, you're making the argument that it's going to proceed how it's always proceeded. But then you also mentioned that in all of the cases that you've tried, you've never confronted this issue. So you've never had occasion to see how this proceeds practically in a courtroom during a hearing.
It's a rare bird. There's no doubt about it. But I don't see how we create a blanket rule that is going to impact the cases on a far more reaching basis than what we speak of now. Because what you're really speaking of is disadvantaging plaintiffs. And that's really where I have the biggest problem with all of this. The idea that the plaintiff is so greatly disadvantaged that the defendant can not only choose not to take the witness stand, but if asked to take the witness stand, can say no, thank you. And that may very well deprive a plaintiff of proving his or her case and obtaining the restraining order. And if we're going to tip the scales, and I started to suggest to Justice Noriega the idea, sometimes we have to look at who's doing the influencing here. If it's the state, it's certainly something more significant. If we're talking about, I hate to say he said, she said, but that is how many of these cases come. It's a level playing field. Now we're going to say, oh no, we're going to go this way. We're going to tilt the balances in favor of defendants. It's exactly what the statute says you can't do.
Well, as of right now, judges can make the determination that there's no evidence to contest what the plaintiff has said. There's no evidence to refute what a plaintiff has said, and they can make that finding, even though it's not as far as an adverse inference. Correct?
That's correct.
Okay. So I want to go back to Justice Pierre-Louis' question, because I'd like to know how the mechanics would work. You've got a pro se defendant. The plaintiff is represented, asks the question, on such and such date, did you encounter the process server? That's all it's asked, nothing more detailed than that. Judge doesn't know where it's going yet. Defendant says, I plead the Fifth Amendment. What happens next mechanically?
What happens next is the judge is going to say to the witness, what would be the basis for your invocation? I would need a proffer.
So now he has to speak to the fact that I may be prosecuted based on my conduct with that process server.
That's correct.
Which is potentially damning evidence in a future case.
No, because the judge is going to, before you ever get to saying, did you point the gun, is going to say, I'm going to not draw an adverse inference. You've invoked the Fifth, you don't have to answer the question. Once you invoke the Fifth, you don't have to answer the question.
But the information has to be revealed somehow for the judge to make that determination.
The information could be revealed in a way as to suggest, Your Honor, I would be in jeopardy if I did so. And if there's nothing to countervail that, then the Fifth Amendment privilege has to stay. You can't draw an adverse inference if there's nothing to suggest that it's improperly drawn either.
Can counsel speak on behalf of the defendant at that point?
There are processes that can happen. The court can call for a sidebar. If there's a real concern that the leaking of this information into the world where the prosecutor sits in the back of the room taking copious notes, as somebody suggested.
Or ordering the transcript.
Right. But the same. Judges do this all the time. Trial judges, sidebar. I'll see counsel at sidebar. You say, what's the issue here? The issue here is he pointed a loaded gun at a process server, and if he says he did so, he's in deep trouble. The judge is going to say, okay, everybody go back to your seats. I'm going to allow for the invocation of the privilege, and I will not draw an adverse inference. So judges can conduct sidebars. Judges have ways to be able to implement that. We trust judges to try cases. It's what we do.
In Justice Noriega's hypo, there is no counsel. Justice Noriega's hypo was a pro se defendant. Do you expect a pro se defendant to even know where to go when the judge says, let's have a sidebar?
Well, no, there wouldn't be a sidebar, but the judge could say, we're off the record. You could turn off the little blue man, like you see here, and make it a blinking blue man and say, you do have the right to conduct out of the hearing where it's something potentially incendiary like this. It could conceivably happen. The judges want to
But
know
shouldn't
why.
every interaction between the court and pro se litigant be recorded?
It can be, but then what do you do? Erase the tape? I mean, that's a bigger foul.
Right, but now we have a situation where that individual is not suspected in pointing a gun, but suspected in a murder. And the prosecutor gets an order reviewing the entire day's worth of audio and now wants a transcript of that because in that colloquy with the judge, the person's admitted to having been involved in that situation. Don't we have a much bigger problem there?
There are hypotheticals that could present these kinds of issues. I think the issue.
Yeah, but I'm just trying to get to the mechanics of how the information gets revealed without jeopardizing the very point the person is making by invoking the Fifth Amendment privilege.
I understand that. And as I said, there is the sidebar with pro se litigants. It is trickier. It is harder. I admit that. Unfortunately, the alternative, and I guess the problem I would have is I would suggest, Justice, what would be the alternative? Because the alternative would be to grant blanket immunity and say defendants need not ever testify, whether they're called or whether they choose. They just never need to testify.
Against themselves, perhaps, is the answer then. They don't need to testify against themselves to help impose the restraining order onto them.
Yeah, but the problem is, again, in this case, my case, I called the defendant as a witness. And I have every right to do so under the law. So how do you deal with that circumstance? Do you say, I'm sorry, but you can no longer call a witness to the stand? Now you're saying to the victims of domestic violence, sorry, but you're going to lose some of your cases, but good luck going forward. Let's hope everything works out for you.
What
Because
information,
that's the other side of it.
what information did he have that your client didn't have, that prevented your client from establishing the predicate acts?
Again, I'm going to tip my hand on this, but the fact is, hypothetically, he might say, yes, I placed the call.
Your client already testified that he did.
My client testified that she saw his father's name on the phone. The phone said the caller was his father. She testified that the individual who answered the phone said, it's so-and-so. She could not remember the name. He could not remember the name, but both did testify. He didn't identify himself as your husband. Both did do that. So now I ask the question, did you place the call? And
Sorry, both who? The third party witness and the plaintiff?
my client both said
The employee at the
employee, they received a phone call and the person identified themselves by a name other than the defendant.
So far, it sounds like you have the proofs.
Stay tuned. So then the next thing is, he doesn't say a word. He grunts in some way, shape, or form. And so the testimony is, I heard his mother in the background, and I heard a noise, and I heard click. But all of that aside, the one element of this case that I really haven't gotten to is intent. Harassment's an intent crime. So the one thing I haven't got to is that aspect.
I'm going to let you finish that, but
Yeah.
just to be clear, this evidence you're suggesting is on the harassment
On the harassment.
Okay. Sorry.
So harassment is, it's in some instances, the placing of an anonymous phone call. I have proofs, not the greatest of proofs, I'll admit, but proofs that there was an anonymous call placed. I'm going to submit that it was an extremely inconvenient hour since my client was running the CCU in the middle of the day when she had a cell phone and all these other things. And I'm going to submit it was anonymous. How do I get to the purpose to harass? And that one is a little trickier. And I do believe I need the defendant's testimony to get to the intent aspect. And I won't be so, I'm pretty good at trying cases. I'm not going to say, why'd you call? Because I don't start a lot of questions with the word why, but I will want to get to the purpose of that call. I might find out it was a benign and legitimate purpose, or I might find out that no, I really did call because I wanted to annoy, alarm, and harass her. I don't know the answer to those because I haven't asked the questions, but I do need his testimony. The other thing is, there's this in the second incident, which is the stalking one. I guess it's loosely into stalking, but driving by her house at a high rate of speed for no particular purpose. Assume for the moment you agree with me, it's a side street and you had no purpose being there. Again, goes to intent. What was your purpose in being there? She doesn't know why he was there. I want to ask him why he was there. First, I want to ask him if he was there in the first place. Then I want to ask him why. And again, I won't say why, but I will say, try to establish the elements. So sometimes I do need a defendant's testimony to prove a case.
So her brother testifies, this was the parent street, right? And testifies about the incident.
Correct.
And presumably could be asked, was this a side street and how many houses are on it? It's not a conduit to an interstate, right?
Correct.
And then the judge hears nothing nothing adverse to that, no contrary testimony. Isn't there enough there under preponderance standard for the judge to find that the purpose was to harass?
I don't know that. I don't know that. And because I don't know that, I wanted to put belts and suspenders on it. I wanted to get to the truth. And so in order to do so, I made the determination that my case was best served by also calling the defendant as a witness. Again, I don't know. The defendant might very well have a very legitimate reason. Don't you realize my best friend lives 2 doors down? I might learn that. I don't think I will. I'm pretty sure I won't. But the fact is, I did not believe that I necessarily had enough that I shouldn't want to also go this extra step.
So let's go back to what my colleagues were asking about process, right? But let's use the actual example. You elicited testimony from the wife, which I mentioned before. I told him guns are dangerous around my son. Then you look to call the husband, and you say, weren't you made aware that flashing guns around the house is dangerous? How does that play out?
It plays out that there'll be an objection to the relevance, because the relevance has nothing to do with his state of mind. It has to do with her state of mind. The only reason that testimony came in to begin with was her state of mind. Her state of mind was, this is a guy who's reckless with guns. That's my perception. I don't have to prove that he really is reckless with guns. I only have to prove that that's how she felt. So that's how it comes in. So your question, Justice, with due respect, I would overrule or I would sustain the objection as irrelevant, because it doesn't matter what he thinks. It matters how she perceives things, what she reasonably felt.
And that objection is made if the defendant has counsel.
Yeah.
Only if he has counsel.
Well, I understand. But again, I say to you, Justice, your alternatives here are keep trying cases the way we always have, or say, yeah, TBVIW was right. Let's now just give a blanket prohibition, something that doesn't exist otherwise, to any testimony from defendants. Defendants no longer, they have a complete immunity, and we're going to no longer permit any adverse inference every time a defendant says, I invoke the Fifth Amendment. It's too far, it's too much, and it will disadvantage the people you're supposed to be protecting. And the expense on the other side, I'm sorry, is slight. I keep hearing about how harsh these penalties are. And let me address that, because it's something, they're not penalties. So we're clear, this is a civil, not a criminal case. To call them penalties, and I admit at one point I read my own submission today and accidentally interchanged the word penalty. Not great, but I did. But the fact is, they're not penalties. These impositions are not at their core designed to punish defendants. We are not giving them Hester Prynne scarlet letters and putting a big A on them and saying, you're an abuser. We're not doing it for that purpose. We are not casting them out like, I don't know, like when Cain got kicked out of Eden and they put the bark of Cain on them or something. This is not what we're talking about here. When we put somebody's name into a central registry as an abuser, it's because they have committed an act of domestic violence. And study and cases will show over and again the recidivism that exists in those who commit acts of abuse. They repeat, they keep coming back and back again. And abusers don't just abuse one victim. So the creation of the central registry was made for protective purposes, as is everything else in the statute. It is not a punishment statute. It is a protection statute. Think of some of the things you're talking about. Don't come to my house. Don't come to my workplace. Don't call me. Don't text me. Those are all things there. Don't text my brother saying, tell your sister this. Don't reach out to any family member of mine, friends or whatever, trying to get messages back to me. Those are all parts of this. Exclusive possession of the marital residence. Let's imagine that that's something ordered. Temporary. It's a temporary rule, because ultimately in the divorce proceeding, the judge is going to decide what happens with that house. But temporarily, we need to protect the victim. by giving exclusive possession. Rulings can be made regarding children, temporary, again, subject to the family court making final rulings saying, look, your action was so unhinged, I only want supervised parenting time for now. That does happen. That can happen. That needs to keep happening. So all of the things we talk about, pets, somebody's got to take care of the pets. I understand. And you know what? We're creating contention areas. Sometimes judges say, from now on, you're going to pick up and drop off your kids at the police station in the safe zone. You ever see those safe zones in the police station parking lots? They're there because there's cameras on them. And so we oftentimes see that this drop off and pickup takes place in a safe zone. Courts routinely have to do this. So all of these are protections of the victim. And I'm sorry to say, I'm tired of hearing their punishments.
I'm going to ask you.
Sorry, Your Honor.
Just a second. Other questions anyone has? Are there any points you haven't raised already you'd like to present to the court?
I don't think so. I kind of went as far as I needed to, right?
Very well.
I thank you. I thank all of you. And I do want to just remind you again, we don't need to reinvent the wheel here. I do believe that TBVIW is the wrong step. It is wrong because it grants this blanket immunity.
I think we covered this already.
Oh, I did. You want me to wrap it up? It's been a pleasure. Thank you.
Thank you. Mr. DeMarco, brief rebuttal. Usually 5 minutes, perhaps a little more, but not more than that.
Thank you, Chief Justice. I appreciate that. I want to start with Evidence Rule 101A2 as it references privileges. The provisions of Rule 500 privileges shall apply without relaxation to all proceedings and inquiries, whether formal, informal, public, or private, into all branches and agencies of the government.
Well, we're on evidence rules. New Jersey Rule of Evidence 532. Do you agree with Mr. Pasquale that it's not relevant here?
I do not. It can be relevant to all proceedings, as we see in 101A2. Garrity warnings, in employment matters, the warnings are very similar to that of a Miranda warning almost in terms of how it can be used. So I don't believe
generally says everything it applies to all proceedings, but there are certain evidence rules that, as a practical matter, would not be relevant to certain categories of cases.
404B, I would agree that would generally only apply to prosecutions.
Even though it's covered, 101 would suggest otherwise. So what is your position on 532?
It has never been used or analyzed in the context of either a civil proceeding or a proceeding pursuant to the Prevention of Domestic Violence Act in the family court. It has never been utilized, but the rule exists there, and the 101 catch-all would seem that it should apply, especially in situations where you have pro se litigants without an attorney who have to make these decisions on whether or not to approach sidebar, whether or not to assert a privilege, how to argue that point finally to the deciding judge. I mean, all of these nuances when we speak about privileges apply not only to represented parties, but also to the pro se litigant. Having observed several trials where defendants have elected to represent themselves, courts have appointed standby counsel. That's probably one of the most difficult jobs for a lawyer, sitting there.
Going back to the question.
Yes.
You think it is, just hasn't been used in all?
It's never been necessarily argued. So it hasn't been utilized, Justice, but I would say overwhelmingly it would apply to criminal settings. But just because overwhelmingly it would apply in a criminal setting regarding the invocation of a privilege doesn't necessarily mean that that privilege wouldn't also be applicable during a civil trial, especially in light of the consequences of magnitude here.
Your adversary took the position that sometimes a defendant in a domestic violence case can properly invoke the protections of the Fifth Amendment. And in those circumstances, the adverse inference cannot be utilized. Why shouldn't this be done on a case-by-case, question-by-question basis? And if we do go down that route, what rules should we impose to help guide lawyers and litigants and judges about how to manage this?
I think a question-by-question basis, a case-by-case basis is a difficult one. Will it be applied differently in Passaic County versus Hudson County versus Sussex County?
But it is the rule that we apply in every civil case now, right?
Well, that is very true. Absolutely. But how are the family court judges, looking at this approach case by case? are some family court judges indicating, well, if there is a predicate act possibility here.
But presumably they're used to, the reason I was asking is presumably they're used to having to do it on a question by question basis in every family court case, because a lot of the cases are civil, correct?
That is correct. Here, I think the point about the derivative use of the evidence is an important one. Justice Hoffman brings it up in terms of the context of gunplay or fear. And, we have to be reminded that this isn't a theoretical case where my client is being prosecuted or potentially prosecuted in the future. He's being prosecuted at present. He's facing second-degree charges here, dealing with weapons, dealing with allegations of pointing a weapon at a process server. Any information regarding those guns, the armory, the fascination with weapons, the pointing or scaring of a child, a prosecutor may look at that transcript, order that transcript, and say, all right, let me look at this line in terms of a potential 404B application. And the protections, which aren't the same as the privilege incorporated in the PDVA, certainly with the holding in Dupree and some of the other cases, it's not the same as a blanket immunity here.
Counsel, when we're calling it civil, we're saying civil cases generally. Would you agree with me that if we're talking about a civil case with a personal injury action, where there's a jury and there's pretrial litigation, there's motions, and one of the defense witnesses is called to the stand and now invokes the fifth, that's a very different dynamic than what happens in the same civil, but PV, the Prevention of Domestic Violence Act cases when an FRO is being issued, and the speed at which those happen and the lack of any pretrial litigation and the lack of any discovery, can those be considered the same?
They're not the same. And one of the things that I was going to draw to the attention of the court is, what if we have a death by auto criminal prosecution and at the same time a wrongful death civil suit? Is there ever a likelihood that the wrongful death civil suit is going to go before the death by auto type of criminal prosecution? Because in that situation, clearly a defendant would have a right to say, I plead the fifth here. I want to take the privilege against self-incrimination. And the court in that wrongful death suit would most likely agree, since there is a prosecution occurring for death by order. I think one of the distinctions also that has to be made here is one of the reasons why we may not have law throughout the country regarding the application of a final restraining order is because New Jersey does it differently. Our final restraining orders are permanent. They're not temporary. They don't expire. Applications can be made after a period of time, but a court has to grant that application. So the permanency of our restraining orders places them certainly on different footing than any other jurisdiction that does not have a permanent final restraining order. I know one of the concerns raised this morning with questions by the justices was, how does this impact in terms of appointing a public defender to these proceedings because of the consequences of magnitude? And obviously that is something that is considered here. But I think the right to counsel pursuant to the Sixth Amendment is a little different in terms of its implication. In theory, if we were to go down that road and say all defendants in a prevention of domestic violence final restraining order shall get an attorney through the public defender's office, the argument could be made that the plaintiff should have an attorney too if they can't afford one, because of those very consequences. So I don't think that this involves the implication of now having a special category of public defenders, but that does not diminish the very true results here, the consequences of magnitude that Justice Albin spoke about. One thing I wanted to bring to the attention.
How could we say that these consequences are so severe that we have to apply a rule that only applies in criminal proceedings and not civil proceedings, but they're not severe enough that you are entitled to counsel, even though you are in a different case that does not have the same kind of severe consequences?
I agree that the line is blurry and it's a difficult line to look at. But just in terms of employment, one of the reasons why our recovery court is so successful, re-entry programs brought forward by former Governor McGreevey, is the ability of an individual to work. It goes hand in hand with success of those on probation. When you have a job, chances are you're not going to recidivate. Here, having a final restraining order placed upon you is a branding of a batterer. It does interfere with union contracts. I have represented union members that if there is a finding, they are not permitted to work on that particular location. It's right in the contract. So for many of those individuals, they accept civil restraints, even though they want to contest a finding of a restraining order and believe they have the grounds to prevail at trial. The risk is too great because it can impact their ability to work. And that is something that is a consequence of magnitude. It can impact your license as a teacher, as a lawyer, as a doctor, as another professional.
Thank you, counsel. Thank you to all counsel.
Thank you, Justice.
Court's in recess for the day.